Oh, it's mute. It says mute.
Hello, Fran. Hi, Fran.
Hey, John Bluen, can anybody hear me?
Yes, John. This is
How you
Peter.
doing? Good to hear. Good to see everybody.
Good to see you guys.
Hi, Peter.
Oh, you're at the Golden Gate Bridge.
Yeah, you know, little sunset going on, hanging out.
That's awesome. I'm kind of on my phone here. I was trying to find the link to do it on my desktop, and I've
If you go to yesterday's email from our clerk,
Yeah.
if you go to the agenda, click on agenda, the agenda has a link on it.
okay.
Yeah,
Okay. Well, I see it's
Will
at the
told me
bottom of
that.
the page.
I couldn't have figured that out by myself. Will told
I
me.
see it at the bottom of the page, but I was looking for an actual link, so I got to go to the agenda and then click on the link when I
Yeah, yeah.
get the paper. Okay, I'll do that. I'll try that.
Let's see, we're still 4 minutes away from 7, so we're not going to do anything official till 7. I'm sitting in a corner of my bedroom. It looks like I'm under an interrogation lamp, I can see. But the alternative, if I turned on the overhead light, I would be very bright. I would look, that's worse.
Yes.
Well, can you see me or not see me?
We see only a
Can't
still
see
of
me.
you.
Yeah.
Pardon me? Do you see my I see like a picture of me, but
Yeah,
is it looking straight up in the air? Because I'm on my phone. I would have to hold it like this.
we see a picture of
No. Yeah, I think your camera is.
Bill.
Okay. All right. So at least you can see that I'm participating, but you just can't see me live. I'll see if I can find the link and join that way. It came from Christian, right? I mean, the town Ridgefield
Yeah.
clerk.
Yes, yesterday afternoon. And I now admit, I've actually looked through it all. I've at least looked at every page. I'm
Me
I'm
too.
not saying I've read every page.
I'll tell you, I was overwhelmed with the packet when I got it. And I did
It
spend
looks
quite a
like-
bit of time going over it.
Yeah, it looks like there's a little bit of repetition, a little duplication, I mean, of pages, but not a lot. Are you with us, Holly? Holly,
I'm trying to figure out how to, I just put this on a new laptop. I have a desktop. It doesn't have a camera. So I borrowed Don's laptop and I'm trying to figure out how to turn the camera on. I haven't figured it out yet, but I probably will. If
Yeah.
not, I'll just listen.
Yeah.
I mean, I'll be on audio.
That'll be
And
fine.
we can hear you well.
Yes.
Everybody can hear me well. I'm very loud. You can probably hear me in Ohio.
I'm in Reed. I'm in Hollow, I guess, and I can hear you just fine.
Oh yeah.
You're coming in great from California.
Are you really in California?
No. That's the one free backdrop I could get on my Zoom account.
Cool.
The first time I found myself in San Francisco and I came up on the bridge in the distance, with all the fog and the clouds coming down. It was just amazing.
Yeah.
So you're saying I can just click on the link that's right there? Yeah. That
Yeah.
Oh,
Here,
at that.
Holly. Working
Oh, we
like
see you now, Holly.
Yeah.
this indeed.
Hi, Holly.
I hate pictures like this. I hate doing this.
Oh, it's fine.
Because then you always see how old you are. It's easy to forget until you have to look at yourself. All right. Well, I'm going to set this aside so I can type the minutes on my other computer. So you're going to get a kind of side view of me, but I'm here. Is everybody here tonight? Is everybody coming?
We're missing Cliff and Henry so far.
Yep.
Oh, I guess I gotta undo my camera. There we go.
Record in progress.
Okay.
John, you are signed in twice, so you probably want to sign out of one of
Yes.
your devices. We're getting a little feedback. There we go. I just hit your microphone icon and your video icon, you'll be good to go.
So you can hear me now, right?
Yes.
Absolutely.
Okay.
Nicely.
Okay. Well, there we go.
There he is.
So you can see I have a couple of screens that I need to hook up elsewhere. I don't have a very interesting backdrop here today.
Is that your real estate office?
Yeah. Figured there'd be less noise or distraction than if I'm at home.
Yes, our 1-year-old cat will probably jump up on the monitor at some point.
So this is an organization. Well, we should probably wait before we say anything, right?
Well, it's just now, it's 7 o'clock. So I don't know about Cliff and Henry.
Cliff's on.
Cliff is on?
Yeah.
Yeah.
And it looks like, is Leah on? Leah looks like she's on.
Yes.
Yeah.
Ms.
Hi,
Hayes,
Leah.
you're there, right?
Hi, I'm here.
Good. This is a public meeting, so anyone may listen in, though it's not a public hearing. So only the board members will be speaking tonight. I mean, if someone else has a question about process and they could try to pose it after I would prefer you wait till we're done with our basic business. But as I said, it's a meeting where we're doing this because, first of all, our ordinance requires that we have an annual organizational meeting, which I neglected to organize last year. And also, so part of it is just organizational, and part of it is also a little bit of a discussion about the procedures that are involved in the pending matter involving Safe Space Meeting House. So we don't know about Henry. My inclination is to start. Does anyone object to that?
No, I can give him a quick call and see if he's coming.
Oh, why don't you do that, Holly?
Can you hear me? I'm having,
Can,
okay,
yep.
Having some technical difficulties here.
As long as you can hear us and we can hear you, you don't have
Okay.
a video.
Henry went to the town office because he didn't realize it was 100% virtual. So he just got back home and he's going to be logging in.
Good thing Henry lives close to the town office.
Yeah. it is.
He just wanted to get out of the house.
Now, for October 28th hearing, Henry was on the phone. So I guess he's where we're not.
Yeah, yeah. So we might as well wait a minute or two for him, you
Yes.
think?
Yes.
Okay.
And is someone on from the Reedfield Town Office also?
I was, I don't know. I don't see it.
Well, I see Reedfield Town Office. It says it's being recorded, but I don't know if it's being recorded by Zoom or by the town office. And if someone's
think-
there from the town office.
Paul, and I see that Chip is on with us, our CEO.
Yeah,
Hello,
they-
Chip.
Hi there, all.
Hi, Chip. I don't see you, but I hear
That's
you.
okay. My hair's not good tonight.
Well, everybody has a bad hair day.
Especially in this cold weather where you put the hat on, take it off, and your hair goes like this.
Yeah, any pretense I have that I still have hair is lost when I have to squash it down with a cap.
Yeah.
Hi, everybody. My apologies for being late. I didn't realize it was 100% virtual, but so here I am on Zoom.
Right.
Hi,
Thank you, Henry. In our hearing in 2 weeks will be hybrid.
Yeah,
So there, people can be in person on site, or they can participate via Zoom.
right.
So let's get going. This is the organizational meeting of the Board of Appeals. The first order of business is that under Section 4 of our Board of Appeals ordinance, there should be an annual election of the officers of the board, that being the chairperson, the vice chairperson, and the secretary. So we have not done that in a couple of years. We need to elect officers. Let me state at the outset that I've been the chair of this board now for something like 10 years. Now, we didn't have a hearing for 4 of those years, but that's really too long to have one person have the same job. And so I would very much like to be replaced as chair. I'd still be a board member because the select board decides who's a board member, but I'd prefer to be replaced as chair. So I wondered if anyone else is willing to step in and be a chair, and then we can see if anyone nominates that person.
Peter, can I just make a point that, first of all, I think you've done a marvelous job as chair in the, 3 or 4 years that I've been on this committee now. The second point I'd like to say is that I think your legal background is essential for the Zoning Board of Appeals and for our process. So I wouldn't volunteer for that, not being a lawyer, but I really just want to thank you for the work you've done. I also agree with you that I think 10 years is a long, long time. And I think the legal background is really important in the job you're doing.
I tend to agree as a theory. Luckily, we have a very well-qualified lawyer also on this board, who's not me.
On trails, the two top guys just switched roles. So that, so you could be vice chair and Will could be chair. So then we'd have two lawyers still at the top.
That sounds like a
Yeah.
good idea.
Excellent idea.
All right. Yeah,
Well,
I'm
I'd be
willing-
willing to be I'd be willing to be vice chair because it usually involves no work, no extra work. Will, are you willing to be chair?
Yeah, I can take that over if you need a rest.
Well, thank you. So nominate Will to be the chairman.
I second it.
Okay.
So
Anyone else? Any other nominations? Going once, going twice? Okay, nominations are closed. All in favor of Will as chair, please raise your hand. And if those of you who can't be seen, please say yes or no.
You can raise your hand on Zoom somehow, but
Oh, you can. Yeah, you're right. But I never thought about that. Does everyone know that?
No.
Reactions and the
I know it, I
reactions.
just don't know what the button is.
yeah, I was
It's
looking
called
for it. too.
reactions. And there's a hand symbol.
Oh,
which
yeah.
I put on for myself.
It's the first one under reactions. So there's mine.
Thumbs up or the hand?
I guess either will
works.
do.
Oh, reaction.
Yeah, any of them. Yeah.
But
Yeah.
if you can't do it, just, raise your hand or say yes, or say whatever you'd like to say.
It might be easier to ask us anybody's opposed, because I'm sure most of us are in favor.
Right? Anyone in opposition?
No,
Anyone abstaining?
no.
Okay, so it sounds like unanimous vote.
Congratulations, Will.
Yes. Will.
Thank you, I think.
Thanks for
By the way,
volunteering. Bill.
If you want to get rid of that hand symbol, you go back to reactions.
Oh,
Oops, I put the wrong thing on.
Lower hand.
Yeah.
And so now we nominate
Lower your
Peter
hand.
for vice chairman.
Yes, I move to nominate Peter Bickerman as vice.
I second it.
All in favor?
I'm in favor. I'm too busy to do my hand thing.
Peter, what's your vote?
Oh, I shouldn't I abstain from my own vote? It sounds,
I didn't.
I'll vote for myself then.
Looks like it's unanimous.
Great. Now, secretary. Secretary, Holly, are you willing to keep going? You're doing such a
I
good
am.
job.
I am. I've
you.
been doing a lot of minutes. The town has hired me to do minutes for some of the other meetings, so it turns out to be like my job.
I'd like to
doing that
nominate
job.
Holly to be secretary.
I second it.
I'd second that, yeah. All in favor? Anyone opposed? Any abstentions? Looks unanimous to me.
Same here. Yep.
Congratulations, Holly.
Oh, thank you.
So that's the first order of business. Second order of business is to approve or not the minutes that Holly did for the our last event, October 28th hearing on 111 Mayo Road. Holly, you made a minor correction yesterday to the minutes we'd previously received.
Yeah,
that
I had the
correct?
title wrong. I had organizational meeting and should have said appeals board hearing, because it was the hearing for the Marashes.
Yes. Were there any other changes?
Nah, well, there was an errant line stuck in there, but nobody cares about that.
I noticed a couple, unless perhaps these have already been corrected. On page 4, this is in regards to the Morash hearing, is that correct?
That's
Yes.
correct.
Okay, on page 4, the second paragraph, the last sentence, I think he wanted to say out of and not into in regards to moving into his house and out of his house and so forth.
That doesn't line up with my version of the thing. What's the paragraph begin with, Cliff?
Second paragraph, page 4.
But what's the first sentence of the paragraph? Because that paragraph on my copy doesn't.
Oh,
line
I
up.
don't have the minutes up in front of me.
Oh,
I couldn't print them today. Okay, it's a paragraph where the comment was made. It seemed a waste for Marash to move into his house
okay.
and then go into a motel. I think he meant out of his house.
I see the paragraph. Unreasonable to ask them to move into the current home and then move to a hotel while I meant current home. They were saying that they had to move into the house that's currently there and live there until they were ready to rip it down and build a new house. So the way I
Oh,
worded it was.
Okay, all right, I understand what you're saying now.
Yeah.
Okay. All right, and then in the third paragraph, the fourth word, there's a word he in there. I don't know what that means. It
Oh,
doesn't
yeah,
change.
yeah, it's just stuck in there. That's a good catch, Cliff. I'll delete
Okay.
that.
All right. But other than that, they look good to me.
Anybody else have changes?
I don't. So can we have a vote on, someone make a motion to approve the minutes?
So move.
I'd make a motion. Okay, I'd second.
All in favor?
In favor.
I'm an abstention because I wasn't able to make the meeting.
Okay,
That's
That's
right,
right.
John. Makes sense.
Okay. All in favor except for John's abstention.
yeah,
Great. Now, moving on, by the way, and now, even though Will is now the chair, it's not clear if there's a transition period, but I think we should give Will a break and I think I'm stuck with doing tonight, being in charge of tonight's proceeding, and then Will and I will figure out who's going to preside at the hearing in 2 weeks. We'll draw lots or flip a coin or something, but if Will wants to, he's welcome to preside in 2 weeks. But I volunteered in a previous conversation. I said to Will, if you take this job as chair, and if you don't want to preside on January 27th, I will. So we'll see what happens. The hearing coming up, you folks may all know what I'm about to say, but I think it's worth me saying it anyway. This is an unusual, normally when we deal with a variance or with a CEO decision, we're having what's called a de novo hearing, where we decided ourselves, we decided fresh, we take in evidence and we listen and then we make a decision. But in the case of a decision of the planning board, the ordinance says that we act in an appellate capacity only. So this is in section 6B of our Board of Appeals ordinance. It says appeals from decisions of the planning board shall be strictly appellate proceedings. Such review is limited to the record of the proceedings before the planning board, and the board, that is we, shall not receive or consider any evidence which was not presented to the planning board, but we may receive and consider oral and written argument. The only exception would be if we thought that the record before the planning board was not adequate, then we could remand to them for additional fact finding. But otherwise, we're limited to their record. That's why we got that big packet and why I demanded I made it clear to the town office that we needed, each of us, to have all the stuff that was submitted to the planning board in relation to this application. I know it's voluminous, but that's why we have it. And the ordinance also says that we cannot substitute our judgment for that of the planning board on questions of fact. So our role is to determine if the planning board did anything that's contrary to the law, that being the ordinance, the land use ordinance, or state law, if that were the case. So our review is quite limited. Our scope of what we're doing is limited here. And so that if anyone brings in, or attempts to bring in facts or alleged facts that were not presented to the planning board, we can't consider it. And the presiding officer in 2 weeks will tell that person, that witness, that we can't consider it and to stop talking about it. We can only deal with the record as it exists. By the way, I think this is a very hard standard for a municipal board to follow as a practical matter. And state law gave towns the option to do it this way or to do de novo. But our town, the planning board was very insistent. I remember when this happened, when we, in our ordinance, the planning board insisted that they be given deference. And that was the position adopted by the town in a vote. I didn't like it, but that's the way it is. So
Peter?
I'm sorry, go ahead, Henry.
Yeah. Hey, could you just clarify a little bit about what the clause about adequacy of information as it relates to facts, I think is what you said, or something to that effect?
I'll read to you what the ordinance says on that. If the Board of Appeals determines that the record of the planning board proceedings is not adequate, we may remand the matter to the planning board for additional fact finding.
Peter, I have a question.
Yes?
The application was submitted on it as an administrative appeal, but in
Yes.
the narrative, they talk about a variance.
Yes,
So which is it?
I was going to get there. Glad you asked.
Okay,
The issue the word variance has come up in some of the submissions we've received. In addition, it came up again in an email that I forwarded to you folks today.
yes,
All right, here's the thing. Under our Board of Appeals ordinance, I know it may be confusing. The first paragraph of our variance discussion in the ordinance, section 7B1, seems very broad. It talks about, we can relax the terms of the land use ordinance, blah, 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 when it wouldn't be contrary to the public interest. But when you read further, excuse me, I'm recovering from a non-COVID cold. So if you read further in the ordinance to the next page, section 7B2, section 7B4, it says, as used in the land use ordinance, a variance is authorized only for height, setback, lot area, or dimensional requirements. Establishment or expansion of uses otherwise prohibited shall not be allowed by variance. Nor shall a variance be granted because of the presence of nonconformities in the land use district or uses in adjoining land use districts. So I think it's quite clear based on our ordinance that we cannot consider a variance in this context, since that it would have to be a variance from a use restriction. This case does not involve, well, the planning board decision, let me put it this way, the planning board decision was not based on height, setback, lot area, or dimensional requirements. And therefore, in my opinion, of course, the majority of the board can always overrule me. In my opinion, the Board of Appeals lacks jurisdiction to make any variance decision in this context. Putting aside the fact that there also that no variance application per se has actually ever been filed, but even if it had been filed, even if a variance application had been submitted, in my opinion, we could not have considered it as a variance. If this is strictly an appeal.
Okay.
Any questions about that?
So we'd be looking at the administrative appeal application.
Yes.
And question 7 has been left blank, and I think it's a pretty important question. What specific sections of the ordinance applies to the relief you are seeking?
Well, I would put, the planning board made a determination that the application was sufficient for them to proceed to the merits. So we don't second guess that. But I think your point is we did ask under our ordinance, we say that the, as you said, I want to get to the exact wording. That there should be a concise statement made, I'm paraphrasing now, that the appellant should have presented us with a concise statement of the grounds for appeal of the specific issue, the specific matters to which objection is made. I know it's in the ordinance, and if I look hard enough again, I'll find it. Let's see. So,
And it's under section 11, 11A1.
thank you. Thank you, Will. A concise written statement indicating what relief is requested and why it should be granted. And I quoted from that language in one of my communications to the appellant. One could argue whether, or one could certainly debate whether or not we ever have received such a statement. We've received many statements, however, and it's made it frankly makes our job more difficult. But rather than, again, the majority, you folks can tell me that I'm wrong and say that we should demand a concise statement before we proceed further. But I had made the call earlier to say, let's just go to a hearing, at which point I would again ask the appellant on the record, exactly what parts of the decision are you saying are errors of law or unsupported by any evidence? There's a lot in what we've received that is not a concise statement. And I'm not sure, some of it's a legal argument, which we should consider. And some of it is an attempt to make factual distinctions, which we don't have the power to do because we can't second guess the planning board on matters of fact. The planning board decision to me is also interesting. I had, of course, no input into what it says or who drafted it or whatever, but the planning board decision, I've read it several times, and to simplify it, it strikes me that they decided 3 different things. They decided, first of all, that to the extent that the structure is partially in the resource protection zone, that there'd be no permissible use, possible use as a social, as a community center or social club, to the extent it was in a resource protection zone. Secondly, it looked like the planning board said that to the extent that the buildings, mostly in the rural residential zone, that this is a change of use of a non-conforming structure, and that there was insufficient, and that in that case, the ordinance, the land use ordinance requires that they prove basically no further adverse impact. I'm simplifying. We'll get into this on the merits later. And the planning boards found that the change of use would have created impacts that were adverse or that extended the nonconformity. But then, having said that, the planning board proceeded to apply the site review criteria. I could be wrong, and we could always discuss this at the hearing, but it seemed to me that the planning board could have stopped after it made the first two determinations. But it applied site review criteria as if there weren't, and found that some were met and others weren't met. My intention is gonna ask a representative of the planning board at the hearing what exactly they intended by that three-part decision. And maybe they'll tell me something, explain it in a way I don't understand, will clarify it for me. What I'm saying, I'm not sure whether we in the end will have to go through every site review criterion to get to an appellate decision. I just don't know. I do know we'll have to go through the first two parts of it regarding the resource protection zone and the change of use in the rural residential zone to figure out if their decision is justified by the law.
Peter, you mentioned a three-part or three criteria for the planning board's decision, and I'm looking at page 7 of 8 of their findings and decision that is dated November 3rd, 2021. I don't see a three-part decision statement there. It's a single sentence on the bottom of page 7. So I wonder if you could just sort of parse that for me, what you mean by three parts.
Go back
Yeah.
earlier in the decision, and the first one really is the requested use on page 3. That goes with, is this really a community center / club? That's issue number 1. Issue number 2 is on the next page. Does it change the use of a non-conforming structure? And then the third issue is all of those 23 site criteria. Site review.
Okay, so thank you for that, Will. I understand that. I guess I was looking for something in this statement of decision, the single sentence at the bottom of page 7 that might have referenced those, but I guess it's really, those are incorporated by reference, I guess.
Well, I found it the lack of a bridge. I thought that's what confuses me. The decision to me is somewhat obscure in what exactly they were doing. The page 7 reference you make, Henry, it seems to be, that's a discussion only of the site review criteria. But if you find, as they did, that you go back to the conclusion on the conclusion on top of page 4, that the application seeks approval for uses that are not permitted in the resource protection district, and that its proposed uses within the rural residential district do not fall within the definition of permitted community center club, the application must therefore be denied on these grounds. That in and of itself would appear to be a decision.
Could be that the site, going through the site review criteria was an exercise to justify the decision that the new use would have a greater adverse impact than the previous use.
That could be, but I'd like rather than speculate, I'd like to ask a member of the planning board on the record what they were intending to do there.
I think that if I were the applicant, I would want the time to put together a concise written statement, knowing how important that is, as to what direction they want us to go. And I think as a board, we might want that before we proceed so that, we're following the applicant's directions for one thing and not putting words in his mouth or coming to conclusions that they didn't ask for. I think that's a important part of the application, in my opinion.
But Cliff, I agree with you on that. And I know there was some email, before Christmas for sure, back and forth with the appellant. And I think we reiterated a request for a concise written statement. And I saw an email from Leah Hayes, I believe, that representing the appellant or being the appellant. And I believe the appellant went back and came up with some more materials. What I'm fumbling for here is there a way in which we as a zoning board of appeals can provide guidance as to what we need for a quote concise written statement? Will's shaking his head, so I'm just raising the question.
I see the concerns with the concise written statement, but they knew the application, and then we asked them for another concise statement and they provided something. And I don't think we should rip what they sent us apart ahead of the hearing. They considered that their concise written statement, and whether it kind of fits in our mind like what we think it ought to be, it doesn't matter. I mean, they gave us something, and I think
that's the way I took it at the time as well, Will. That's what I interpreted it as well. But based on this conversation, I wondered if it was worth raising that question about asking for a more concise statement. Yeah.
Well, now my feeling about it was similar to Will's. The applicant was given at least two opportunities to, the matter was mentioned. They provided a statement. They seemed to see, maybe they felt that was a concise written statement. And my other concern about pressing that issue right now, I think it's a legitimate issue to be dealt with at the hearing. You can ask, in asking the appellant exactly, be more exact, but in terms of holding up the hearing now, even though, let me emphasize, we're not concerned about prior history involving the town. We're concerned only with this application, but I would point out in their briefs, the town has been accused of delaying. I don't want, again, I'm not going to express that's beyond the scope of what we're doing, but I don't want to give grist for that mill here. I mean, if they feel that's their concise written statement, my feeling is let's go to a hearing, and it's because it's not our obligation as a board to make up the reasons. It's the appellant's obligation to articulate the reasons.
Correct.
Yeah, I agree with that. Thank you, Peter. It's in preparing for this organizational meeting and thinking about the formal hearing in 2 weeks, there's just a lot of verbiage to wade through, and conciseness would be a welcome commodity in trying to really cut to the chase on what is being appealed here.
Oh, I understand. Before I forget, something else I wanted to mention. The town government made a decision that the Kristen Collins, who normally serves as the town's attorney, will be in this proceeding, but on behalf of the planning board, will either present the case for the planning board or will advise the planning board on presenting the case. And that moreover, the town government made a decision that we needed our own lawyer, outside counsel, to advise us on how to behave in this situation. And so they have retained a fellow named Jim Kostaiafis, I just messed up his last name pronunciation, Kafiatis, from the firm of Perkins Thompson in Portland. I've spoken with, he said, just call me Jim. So I'm going to call him that. I've spoken with Jim. He is we made a decision, he didn't need to be here tonight, but he's going to be with us by Zoom, if not in person, on the 27th. And and so providing, he'll tell us if he thinks we're doing something off base, presumably he will tell us. I see a chat entry from Ms. Hayes that says, oh, my chat is malfunctioning, but it says that if Ms. Hayes, I didn't want to press you on this, but you volunteered saying if we think a more concise statement would be helpful, you can provide one. Yes, we would like one. If you can provide one, absolutely. You can even, I will say, if you can provide it no later than 7 days before the hearing, send it to us by email. That's fine. You don't have to do it in 2 days. But I would appreciate that. I think we would, and I'm not the only one who would appreciate it. But I'm not going to require you do it.
Yeah.
Okay?
Okay. Okay, I can send it. It's all right.
Because
Peter,
we
can I-
can't be, humanly, we're not going to read, we can't all read 400 pages of stuff.
Oh, no, it'll
For
just
the
be a
hearing.
statement. It'll just be a statement
Peter,
Uh,
of what we're
Wouldn't
looking for.
wouldn't that be considered new evidence?
No, the issue is which issues they're taking objection to. That's not evidence
Okay.
in and of itself. Now, the phrase, there are times when in doing that, people can try to, they'll present things that are in fact new evidence, in which case we can't consider it. But then we have to match up, it becomes a little tedious, but we'd have to match up the argument with what's already in the record to see if it's whether it's new evidence or old evidence.
I won't say anything new. I won't introduce any new evidence. I will just state what we're looking for and hoping for in a concise statement.
Ms. Hayes, I know this is difficult for a layperson. We'd appreciate anything to pin it, to clarify it, or to narrow the issues. Ms. Hayes, am I correct that there's no lawyer at this point representing Safe Space Meeting House?
That's right. He's on, I don't know, I guess you'd call it retainer, but he's not currently available, right?
Now, is this Mr. Smith or Mr. Davis?
Smith,
I see. Is so Mr. Davis is not in the picture.
no, not at all.
Just for purposes of full disclosure, Mr. Smith and I were both members of the same law firm for 3 years.
Oh, I didn't know that.
Yes, I was an employee of the firm of Lippman and Cates from 2013 to 2017. And Mr. Smith came aboard in 2014, I think. So we did a little bit of work together.
So is that okay? Are we allowed
Yeah,
to?
it's fine, it's fine. Unless someone, I think
the statement should include exactly where the errors lie in the decision, not just what they're looking for, but based on what errors specifically.
yeah, well, that's right.
Yeah.
Trying to identify what you believe, what your organization believes was an error, what's erroneous about that planning board decision.
Okay, so what we're hoping for and what we believe was in error.
Just with the
What the errors are. You can discuss at the hearing what you're hoping for, we can get into, but we need to know the errors that you're identifying.
Okay, so just what I believe the errors are. Okay.
Yes.
Okay.
And so, well, thank you, Ms. Hayes. Just finishing up then with as I was mentioning before, there'll be at least 2 lawyers involved on the 27th, present by Zoom, Kristen Collins, and Jim Kafiakis. And if Mr. Smith were to appear, that's fine too, of course.
Okay,
But it's a hybrid proceeding we're going to have, meaning people can participate by Zoom or they can participate in person.
okay,
And here's the bad news, folks. For those who come in person, and everyone in the room needs to be masked. I don't care if you're vaccinated or not at this point. I mean, I do care, but even if you're vaccinated, you need to be masked. I've been back. I've said this is a condition. I've told the town manager this is what I would require, and the town manager said I could do it. So please, Ms. Hayes, you might want to. This applies to the board members and it applies to the audience. So just let's get that message out, because for health reasons, it's just imperative from my point of view. And if people who don't want to be masked can participate by Zoom. I think we may have we've covered the things that I knew we had to cover, but there may be other issues. Any other board members with comments, questions, comments?
I might throw out a comment on this hearing that's coming up. I find, at least for my mind, this kind of hearing is easier for me than like a hearing regarding a variance for a heat pump or a house on a lake. Because those variance hearings are new hearings where we do take new evidence, and we're kind of getting the issue, taking it a fresh take at it. But on this one, we have a nice 8-page decision from the planning board. And it's those 8 pages, the last 8 pages of all of our materials, that decision. Those are the 8 pages that guide us through this hearing. And what we as planning board members and the applicant and whatever participants show up, they just are going to look at all of the things that the planning board wrote in that decision and say, 1, is there evidence in the record for that? And then 2, is that correct? Is that a correct interpretation of our law, applying those facts to our rules? And so, at least for me, I think this is an easier type of hearing because we don't have to like reinvent the wheel. We're just working off of this decision from the planning board. And we're just saying, is that right or not? And is there support for what's in that decision in all these records? So those are my 2 cents. I think this type of hearing can be easy. I think there's a lot of pages, but at least for me, as I'm going through the current planning board decision and I'm trying to figure out, is there factual support in the record for this? A lot of the submissions that have come after the planning board made its decision don't address the decision at all. So I find that kind of easy. So those are my 2 cents on this type of hearing that's coming on.
I agree. There's an awful lot of a lot of things that have been written that really have nothing to do with our function here. And it doesn't really, nor does the history. I believe that the Board of Appeals has made, 4 separate decisions involving this particular piece of land since 2014, starting in 2014. But none of those decisions have anything to do with this one, in my opinion. I'm not concerned, for example, with the meaning of a consent of a consent agreement in 2017. I'm not concerned about a stop work order in 2014. And we're working here, we're reviewing a planning board decision for a proceeding that began, in 2020, but then reapplied in 2021.
I have a question about something Cliff brought up earlier. He's something about a variance, and Peter explained we wouldn't be doing any kind of variance. Why did you ask that, Cliff? And are
did-
they asking for a variance somewhere that I missed something?
In their narrative, on page 7, I think it was, of the brief
Uh-huh.
at the top, they say they are requesting a variance.
Oh, I see. Okay. So we just ignore that?
Yes.
Okay.
Cliff, were you referring to the amicus brief?
It's the one dated January 3rd. It says trial effects by jury. Well, it's stamped January 3rd at the top.
Yeah,
It's a brief in accordance with Rule 80B.
It was right at the
Maybe-
top of the packet, right underneath the findings of fact and the letter.
right.
I'll find it.
It's the most recent document, I think, that was submitted.
So why do they submit numerous? Why do we have one dated December and all that? Do they just keep redoing them? What?
Well, I'm not gonna, I think, I'm not gonna speak for Ms. Hayes, but I know in her cover emails, she said there was some reference to the idea of trying to collect their thoughts and putting in all the issues they wanted us to consider, but I don't know why I mean, we didn't ask for multiple submissions, we didn't ask for them, but we got them.
Okay, all right. So it's only the most recent one that we're gonna really be,
I
that
think
and the findings of fact are gonna be our two things that'll be our biggest focus.
my opinion is you only need to read the most recent brief.
Okay,
There is also that friend amicus, which is friend of the court brief that Mr. Bitar submitted, but you can read that too. But again, it's very similar to the last brief we received from a Safe Space Meeting House.
okay, I get it.
Oh, by the way, let me add, and I should have said this earlier. Again, our jurisdiction's limited. Any claims of unlawful discrimination are beyond our jurisdiction. We cannot possibly decide those, resolve those. If they're going to be resolved at all, it'll be in a court.
You mean like if they're claiming that so-and-so was like biased against them or something like that?
Yes,
Okay. So we're just looking at the facts. The planning board meeting, I did the minutes for the planning board meeting in September. And it was extremely long, almost 4 hours. And the attorney was there, Kristen Collins was there. And they seemed to be trying to cover everything from what I could tell. So, but that's where we get the findings of fact was devolved from that meeting and the follow-up one, right?
yes. I read your minutes this afternoon and they're very helpful.
Oh, well, thanks.
Yeah, those were good minutes.
The recording was excellent. Eric did a great job on that one. Sometimes the recordings are kind of sketchy, but that one was good.
What I'm hoping to avoid this time around, I don't want anyone getting up and discussing, impugning other people's motivations. This actually happened, if you may remember, in the hearing we did in 2018, where the town manager started talking about someone's motivation and I cut him off.
Yeah, yeah.
So we're looking at the record here and making a decision based on what the planning board did. That's all.
I think the other thing we want to
Helen.
avoid is starting the whole review process all over from scratch again.
Well, we can't, we're not allowed to.
No,
Even if we wanted to, we can't.
well, yeah, we can't.
Well, so the fact that you said that the attorney that they've assigned Kristen Collins to be the attorney for the planning board,
Mm.
and the fact that she was involved in the hearing, does that mean that she'll be doing all the talking instead of Paula?
I have no idea.
Oh, okay. Just curious.
You know, You know, I like being retired, but I always find it strange when I'm having a conference with these days with lawyers about legal stuff and they're being paid and I'm not.
Yeah.
I found the same with code officers.
This has been very helpful for me to be able to frame this as we're reviewing what the planning board decided on. That's what we're looking at. We're asking the appellate to say where they feel that system is not correct, or errors or omissions from that. And that's easier to understand about what we're allowed to review is that.
I agree also. I think Will stated it well that this should be one of the easier hearings that we have to decide on, because we're just basing it on existing facts, whether they were right or whether they were wrong, in my view. So I think this meeting was very helpful, and Peter, you did a good job in laying out the format and the background and the proceedings. So makes it easier for all of us, I think. Appreciate it.
I would just like to say that what we're being asked to do as a Board of Appeals is very clear after this conversation, but it's hard to use the word easy in the reference to this entire, issue that is before us. That it's, it's very complicated, but our job is not complicated about what we have the authority to review and decide.
I'm going to throw out there as well. I think it goes back to some of our previous appeal hearings, where I think generally as an appellate administrative body, this is what I do as my job. I don't do it with 7 other board members. I'm the only board member when I'm doing it. I find it very easy to do these appeal hearings because it's just that appeal issue that's in front of us. In this case, it's just a decision from the planning board. There happens to be a lot of decisions, sub-decisions in that decision from the planning board. On another appeal, it could be just a single decision from the planning board. And, it would be much more simple than this. But we, as an appellate body, we just look at this very narrow issue in front of us and we decide on that. And sometimes we get some crazy fact patterns. And it comes out where we have a heating pump that's really close to Pea Ridge, and everyone thinks, wow, there's no reason this woman shouldn't have a heating pump. And yet somehow our regulations say, she really can't have a heating pump there. Same with a house on the lake. Our issue was super clear on that variance, and yet it really morphed during the hearing into, well, the applicant should really be able to build the house of his dreams on his lake property. And we really got, as a board, we got confused on the issues. We let these side issues from the applicant distract us. When for these appellate hearings, it's a super narrow issue usually. In this one, there's a lot of super narrow issues. There's a lot of them, but they're narrow and they're really not that hard, I think, to parse out. And I think just as an appellate body, we've really got to focus on these issues in front of us and not get distracted by the larger issues of how the applicant is faring through the planning board and the select board and the appeal board. That's way above our pay grade. We don't care about that. If you want to change the land use ordinances, go to the election box for that. For us, as an appellate body, the issues seem to be super narrow. And as long as we can keep them that way, I think we make our jobs much easier.
Yeah,
Thanks for that reminder, Will. And I think you're smart to recall some of our past proceedings. And I do think we got a little mired down in some of the backgrounds in some of those. And I think your advice, if not admonishment, is well taken.
No, I'm part of the board, so I take full responsibility for our decisions.
Well, Mr. Marash was back at the planning board last week, or 2 days ago. So we may see him again.
I assume our Marash decision did not get appealed to Superior Court?
No,
That-
he's
that's
redoing
correct.
his application. They're gonna move the road,
Okay.
but,
I guess there was no resolution at the planning board the other night.
well, they
There
didn't have all the
was,
details. They didn't have there was like 3 things. They hadn't gone through the part of the ordinance that calls for certain rules about roads. And there was a couple of other things. And then Paula said she was gonna check with an attorney on a detail or 2. So they had like 3 or 4 things that they were gonna come back again to have another meeting. They're not gonna go to a hearing yet. They're gonna have another meeting.
There's a new chat from Ms. Hayes that's just been posted. I think she's on the right track, and I don't know whether we want to address that in.
I didn't see the whole thing, just part of it.
My chat function is misbehaving, so if someone could read it to me, I'd be happy.
Yeah,
You only
Go ahead,
need
Henry.
the most recent brief. The first one was a rough draft. If the planning board made an error in fact, or an error in law, or an error in process, we will address these issues when we write the concise statement.
Good,
okay, good.
thank
Good.
you.
That's what we need.
I mean, like, on the planning board's decision under site plan review criteria, the first criteria, the planning board said that the applicant met it. So I assume that the applicant is not appealing that decision.
One would assume not.
I'm
So I-
sorry, I don't know what you just asked. I'm sorry.
No, I think the issue is you only have to focus, I mean, you only have to focus on those findings which were negative to your application. The planning board made several findings that were positive on certain other criteria. And those, of course, you don't have to discuss. So that's right. But there is, of course, that threshold issue of whether the resource protection zone issue that may have to be addressed, as well as the change of use issue, creating more adverse effect. But again, I'll leave it to you folks to give us a more concise statement. And we'll look forward to that.
Okay, so I will just discuss the things in which we find to be in error. Is that what
Yes.
you're clarifying? Will, I see you shaking your head, so can you clarify?
No, I'm shaking my head because yes, that's the whole point of an appellate process. So yeah, that should have been done from the very first day.
Well, I will happily submit a concise statement for what I feel is an error.
I know it's difficult, but at the same token, you understand, Ms. Hayes, we're all volunteers also. We're volunteers. So there's a limit to how much time we can devote to a voluminous record. So we need some focus, that's all.
Right, I will keep it concise. I won't send you a lot. It'll be short and whatever I think needs to be addressed.
Good, thank you. Anything else we should discuss before we adjourn?
Am I doing the minutes?
I hope so.
Oh, I mean, excuse me. I mean, am I doing the minutes at the hearing? I'm assuming I am.
Unless
Holly,
the
I'll jump
town-
in. Eric Dyer here. I'm planning on having town staff perform that duty so you can focus on your primary responsibility, which is to be a part of the discussion.
Okie dokie.
Oh.
Good idea.
I was just gonna say Happy New Year to everybody.
Yeah.
Happy New Year to you too, John.
Thanks.
How's the real estate business these days? Booming, huh?
It is continuing, yes, to be booming.
All you need is listings, right?
There is a lack of inventory for sure. All across America. Cars, trucks, boats, planes, everything seems to be in short supply.
Yeah.
Peter and Will, as our chair and vice chair, do we need to address any of the other matters that came forward in the email from Ms. Hayes today, Peter, that you forwarded to the group? I'm thinking of recusal concerns, if there are any.
It is, in my opinion, it is up to the appellant to make, if they feel someone should be recused, they should make a motion and we'll consider it on the record as we do, applying, there'd be two, I mean, we have a conflict of interest statute, as you know, a conflict of interest ordinance that applies to people who have a financial interest. Conflict should recuse themselves, but there's also a common law recusal basis if someone, because of prior knowledge, has been so involved that they feel they cannot fairly and honestly adjudicate the matter before them, then they may wish to be recused. But of course, any board member can say, well, gee, maybe I shouldn't be involved, and we can then discuss it and vote on it. Or an appellant, another party, can make a motion. That hasn't happened yet, and I'm not going to speculate. I don't that it should be or shouldn't be, and I'll just leave it at that.
Fair enough. Thank you.
Peter, if this meeting in 2 weeks is like going, if we're starting at 6 and it's still going at 10 p.m., what are we going to do?
Because of the nature, because the nature of this appellate proceeding, there's no way it should be going at 10 o'clock.
Okay.
It means that whoever's presiding, whether it's you or me, hasn't stopped irrelevant stuff.
We'll call for pizza.
Okay.
I think for health reasons alone, we shouldn't go more than 4 hours. If we have to, I guess we'd have to adjourn recess to another date. I wouldn't want to go more than 4 hours for sure.
Let's lower the number, like.
Because this isn't a kind of hearing where people are, if people from the audience start talking about the good, the bad, and the ugly, as they perceive it, I'm going to stop them. I'm going to say there's nothing. That is not what we can consider today. If you've already made a comment on the record of the planning board proceeding, we've read it. But don't tell us now, if you haven't made that comment with the planning board, don't talk to us now about your opinion about good, bad, ugly on this application.
There's another new chat from Ms. Hayes to everyone, which reads, shall I include this, friends, the recusal, along with my concise statement, or state it here? Is your question?
I think, Ms. Hayes, if you want to make a motion to recuse somebody, it ought to be in writing and submitted to us at least a week before the hearing, so we can consider, we'll rule on it at the hearing.
I also think that what I talked about as far as this meeting was that we weren't going to have a question and answer period. We're just setting up the stage for the next meeting.
Well, you're right, but since the issue came up it's better that people know the ground rules now rather than it come up as the first time when we start the hearing. But we're not going to make any rulings today. That's right. That's why I say, if you want to make a motion of some kind, make it a week, get it to us a week before, at least a week before the hearing, and we'll rule out at the hearing.
Okay, thank you.
Anything else we should talk about?
I'm ready for my dinner.
I move to adjourn.
I second it.
All in favor? Yes. We're all
Yes.
Okay.
great. Thank you very much.
Thank
you,
you.
Peter.
Thank you,
Adios.
Peter.
We'll be in
you.
touch. I'll be in touch
Yep.
with you before.
Sounds good.
Good night,
Good
everybody.
evening, everybody.
Bye, everybody.
Bye.
All right. Good evening here.